Janae and Ashleigh limited Sarai and her siblings' intake of water and food. Janae and Ashleigh did not allow them to eat often and only allowed them to drink 8 ounces of water a day.
It is a truly heartbreaking case out of Hawaii, where a mother and her girlfriend are accused of starving, beating, and ultimately killing a 3-year-old little girl while allegedly abusing her 3 siblings. Court documents reveal alleged systematic starvation, beatings, even a witness account of the purported abuse. And we're going to break it all down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Let's head over to Kapolei, Hawaii, because that is where a mother and her girlfriend are now behind bars. Why? They are accused of starving, beating, and ultimately killing her 3-year-old daughter, Sarai Perez-Rivera, while also subjecting her other siblings to horrific abuse. The details of this case, as revealed in court documents and police statements, horrifying. It paints a chilling picture of prolonged torture and neglect. That's what we're talking about. That's how disturbing this case is. And it begins, this story, on the night of June 13th, 2024, when first responders were called to a townhome in Kapolei, the home of Sarai mother Janae Perez and her girlfriend Ashleigh Utley. They had reportedly been dating for 4 years. And that is when authorities found Sarai's lifeless body. And her body reportedly also showed signs of extreme abuse. Honolulu Police Department Lieutenant Dina Tomes recounted the child's horrifying condition during a press conference last week, saying first responders found Sarai malnourished and pulseless, with ashen skin and bruises to her legs, hips, arms, face, back, and head. According to reporting from the Mirror, a woman who used to live with Perez and Utley allegedly told the police about the abuse after Sarai's biological father had reported her death last year, prompting the investigation. But it wasn't until months later that the full extent of this alleged abuse came to light. The court documents revealed that security footage captured from a neighbor's camera on the night of the girl's death allegedly shows Perez carrying her, who apparently, by the way, she wasn't moving at all, carrying her to and from the parking lot. Now, before we go any further, I want to bring back onto Sidebar a friend of the show, practice professor of law, former prosecutor who has focused on domestic violence cases. Marian Braccia, thanks so much for coming on. It's good to see you again. You know, your thoughts on this case and how it compares to ones you've seen in the past, because we will go through the other details about what allegedly happened to this girl and her siblings, but how does this case compare to other ones that you've seen?
Well, I don't think there's really a continuum, right, that you ever get used to seeing when a child is tortured, when a child's life is just ended so shortly and is just plagued with such abuse and such violence. So how does it compare? It's absolutely horrible. But again, that's to say that anytime a child is subjected to any kind of danger or violence or neglect, it's just as horrible as the next case.
The neighbor's security footage reportedly shows Perez carrying her daughter's essentially motionless body. That feels like a key piece of evidence, unless you think there might be a way to otherwise describe it or characterize what it is from a defense perspective.
Well, I think you're right. It shows knowledge. It would be proof of knowledge that this child was not thriving, that this child was non-responsive, or as you've described her, motionless. It makes it rather difficult for the defense to argue that her mother had no knowledge, had no idea that she was suffering or perhaps even losing life. There could certainly be a defense argument, a defense theory that the mother was seeking help, was seeking fresh air, was seeking other outdoor alternative that would have exposed this child to a different environment. I don't know that that would carry the day, but I could imagine the defense saying that, you know, she was taking the child out, seeking help, seeking a pediatrician, seeking, as I said, some fresh air. But I don't know how much of the ring of truth that would have.
It seems to me there's a part of this case that needs to be addressed, where you have potentially the testimony of a woman who previously lived with the suspects. You know, you also will be talking about neighbors as well. But what is the role of that witness testimony in these kinds of abuse cases? And also, what is the reporting obligation on third parties if they suspect or know about child abuse?
Yeah, that's a great question, Jesse. So I think that this third party's testimony is going to be absolutely necessary, because this was not just a one-time incident. This was not a horrible accident or one instance of abuse. This woman's testimony, the woman who used to live with this couple, this woman's testimony will be necessary in order to establish course of conduct. It'll be necessary to establish the word that you used, which was prolonged abuse, that this wasn't just a one-time incident. And then it becomes very difficult for the defense to argue that this was discipline that had gone awry or discipline that had gone on too long. This was something where there was clearly intent, and these two adults knew what they were doing to not just this child, but 3 others in the household. So this independent witness's testimony is going to be, I think, key for the prosecution. In terms of reporting requirement, unfortunately, I don't think that, and of course, every state will have different regulations and requirements that apply. But if this woman was not what's known as a mandatory reporter, not a teacher, not a guidance counselor, not a medical professional, she would not have a legal duty to report her concerns or her suspicions of abuse, or even, frankly, her observations of abuse. There really is just the moral compass that applies to say, a reasonable, rational adult, is this something that should be happening to a child, or are there authorities and other services that need to be aware of how this child is living and the circumstances under which she's living?
And from a legal point of view, I get it. I get it. You don't want to expand the liability for a neighbor or somebody passing by, or it can be tough. But from a human point of view, whether it's this case or other cases, the idea of if somebody knew something before and it could have been stopped, and I'm not suggesting that's what happened here. That's that part that's just incredibly troubling. Now, I actually see the crime scene here as the girl's body. What do I mean by that? Let me go to the autopsy findings. So the medical examiner's report revealed a series of deeply disturbing details about the condition of this little girl's body. According to the court documents that were reviewed by KHON2, the autopsying pathologist, Dr. Masahiko Kobayashi, noted that Sarai had numerous contusions or bruises on her head, her extremities. She was also found to have a markedly low body mass index and an extremely atrophic thymus. This is a condition where the thymus gland, essentially for development immune system maturation, is severely reduced in size and function. So this gland can shrink due to factors such as infections, stress, malnutrition. Additionally, Dr. Kobayashi noted that Sarai was significantly short and underweight for her age, ranking in just the 3rd percentile. Her height was recorded at 35 inches. Her body weight was a mere 20.5 pounds. And these findings, the medical examiner concluded, were clear indicators of child abuse and neglect. And ultimately, Sarai's cause of death was ruled to be the combined effects of dehydration and starvation. So, Marian, when I say that the body of this girl is like a crime scene, it tells us so much. And you're hearing about this. What are you taking away from it?
I completely agree with you that her body is in fact part of the testimony in this case, that you're absolutely right, that the prolonged exposure to dehydration, to a failure to thrive, a failure to grow and to mature, to grow in terms of both height and weight, and of course, all of the injuries that were observed and documented in the postmortem examination. It absolutely tells the story of this girl's life, again, not just on the night that she died. It takes a long time for injuries to show on the skin. It takes a long time for those injuries to heal. So if you are seeing injuries over a course of period of time, and if you are seeing a child who is failing to thrive, she's not hitting height and weight thresholds or markers, she's not hitting 50th percentile, and she's consistently near the 0 percentile, that tells you that this abuse, neglect, and deprivation was happening over a lengthy period of time, probably the entirety of her life. And again, that will help prosecutors prove the intent element of these crimes and the knowledge element that these two defendants were doing something intentionally. That
was my question. When you have something like this, how does it dictate what prosecutors are going to seek, whether it was a murder charge or a manslaughter charge or a criminally negligent homicide charge? Just generally speaking, when you look at these kinds of injuries in these kinds of cases, how does it determine what the perpetrators or the suspects would be charged with?
Yeah, it's a great question. I think one of the hardest things to prove in criminal law from a prosecutor's perspective is intent, specific intent. That means that you have to get inside the accused mind and show what they were thinking, what they wanted to do. How can anyone ever do that? Ordinarily, when people testify about what someone was thinking or feeling or seeing, there's an objection to speculation because we can't get inside somebody else's mind, get behind somebody else's eyeballs and testify about what they were seeing or hearing or experiencing. But in the case of intent, what the prosecutors have to prove is just that these two actors, these two defendants intended to do something, that they were acting with the specific goal of starving this girl, dehydrating this girl, causing her not to thrive. And that is something very, very difficult to prove. And so showing that this prolonged activity, that these prolonged circumstances of this child's suffering are evidenced by the medical examiner's report, by the autopsy, by the medical records, that will certainly help to prove intent. And that does go into, or I would assume, factored into the prosecutor's charging decision to seek out homicide charges.
Can the defendant say, I wasn't aware, all this was going on with the child? Maybe even not the mother, but the girlfriend. Is that a defense you've seen before? And is that ever a successful defense?
Yeah, absolutely. That is a defense that is seen, I think, quite often when there are co-parents, co-defendants, two or more people who are responsible for the care of a child decedent. It turns into a pointing fingers defense. So this one was supposed to feed her, or that one was responsible for discipline, and I wasn't aware of what was happening. I think what will be key to the prosecution's proof in that regard, to prove that these two were certainly aware of what the other was doing, and perhaps even acting in concert, acting together. What will be very important is not only the testimony of that former cohabitant, that person who was living with them, but also, unfortunately, the testimony of the other children, who will be able to testify that both of these women, both the biological mother and her significant other, were acting together, disciplining together, and making these decisions about the deprivation of food and water and other intake together.
I'm glad you mentioned the other children. Let's talk about that, because in the weeks following Sarai's death, police began unraveling just more details of what was this girl's short and tragic life. And according to court documents, while Sarai ultimately succumbed to this alleged abuse, she wasn't alone in her suffering. We have her siblings, 2, 5, 6. They were also allegedly subjected to the same cruel treatment. The woman who previously lived with the suspects told investigators that Perez and Utley would, quote, mainly whack the kids with their hands, but also hit the children with sticks and paddles. She added that the couple would often beat the children in front of the others, forcing the siblings to witness what was going on. And the documents that were reviewed by KHON2 reveal that the oldest child, the 6-year-old boy, was allegedly beaten after attempting to run away not once, but twice. And when he was caught the second time, court filings describe just a brutal scene where he was dragged out by his ear, his hair, and Perez and Utley both started beating him. Utley allegedly used a long stick and screwdriver. Perez used a short 2x4 to whack him on the legs and arms. And get this, apparently, the 5-year-old boy was allegedly blamed for Sarai's death. Perez Utley reportedly telling him it was his fault. Now, this alleged abuse, it wasn't limited to physical violence aside from the psychological harm that you just heard about, or the alleged psychological harm. The woman revealed that Perez and Utley had systematically starved these children. Listen again to Lieutenant Tomes.
Through the investigation, it was learned that Janae and Ashleigh limited Sarai and her siblings' intake of water and food. Janae and Ashleigh did not allow them to eat often and only allowed them to drink 8 ounces of water a day.
So according to court filings, the children were severely restricted in their access to basic necessities. The documents state that the children would, quote, get about 2 inches of water from one water bottle after each meal. They would sneak out of their room to get a water bottle and drink water. The children had to stay in their bed all day and sleep, or eat lunch in their room at least once a week. If they slept past dinner time, they wouldn't eat. And the surviving children also apparently spoke to police, providing heartbreaking accounts of their sister's final moments. The 6-year-old reportedly told investigators that Sarai was, quote, making weird noises on the day that she died, noises that sounded like she was, quote, suffering. The 5-year-old, in a moment of just innocence, confusion, told police that Sarai had gone, quote, up to see Jesus. And then he asked if Jesus had food in heaven, explaining that his mother had told him Jesus doesn't eat or have food. So Marian, again, you have not only other alleged victims, but witnesses. This is unthinkable.
It is. That's all I can say. I don't think too much more commentary that can be added to that. This is horrific. It's perhaps a nightmare scenario that nobody would wish on any other living creature, let alone a defenseless child. And the fact that these two adult women would first attempt to shift the blame to a child, to a 6-year-old child, is, in my opinion, truly depraved. And I don't think that's something that will go over well with a jury of fact finders if that is brought to light in evidence.
And let me ask you this, because you might say, a defense attorney could say, well, listen, these are young children. There's an issue of credibility. What are they saying? Do they know what they're saying? But the physical condition of the children, doesn't that support their credibility?
Absolutely. Absolutely. And I'm glad you said that, because all of the evidence taken together. So you have the neighbor's video footage where one defendant is carrying the child in and out of the parking lot. You have the testimony of at least 2 of the 3 other siblings. The 2-year-old would probably be too young to pass a competency evaluation and be qualified to testify in court. You have the adult eyewitness testimony of the former roommate or the person who was living with them. You certainly have the expert testimony of the medical examiner who will report on all of the injuries and the condition of Sarai's body post-mortem. All of these things, all of these factors provide corroboration. The prosecutor won't have to convince a jury that all they have is the testimony or the word of a child witness. They have what sounds to be, at this point, a pretty sizable body of evidence against both defendants.
And there's more evidence. I didn't even get to this. So according to local affiliate KITV, videos found on Perez's and Utley's cell phones apparently showed Sarai crying in severe discomfort and distress, begging to use the bathroom, saying she was thirsty. In one video, Perez can be heard allegedly yelling and swearing at this child in response. And neighbors also reported hearing the children crying frequently. You have one neighbor who told KITV, quote, "I remember hearing them multiple times just cry upstairs. Some of them were crying. Some of them didn't really know what was going on." And it took more than 7 months for charges to be filed. But just last Thursday, finally, police announced that Perez and Utley, they were arrested, according to online arrest records. Both women were charged with second-degree murder, 2 counts of kidnapping, first-degree attempted assault, hindering prosecution in the first degree. And Hawaii News Now also reports that they have officially been indicted, and the women were charged with endangering the welfare of a minor and persistent non-support. One of these charges, the persistent non-support, you may not be widely familiar with. It's our understanding is a misdemeanor under Hawaiian law that occurs when someone intentionally and repeatedly fails to provide support to a dependent, which can include a spouse, a child, another kind of dependent. And the charge applies when a person knows they're legally obligated to provide support, able to do it, but fails to do it. And this support can include necessities like food, shelter, clothing, education, other essential care. By the way, we were able to find out some more information on Janae Perez on TruthFinder, the powerful background checker that we use when we're researching stories like this one. And TruthFinder didn't locate any criminal history for Perez, but we were able to identify places that she lived, contact information, possible relatives. And look, Law&Crime, we partner with TruthFinder. It is an incredible tool that we use to get details on people involved in our stories. But even if you don't work in true crime, this can be an excellent resource to give you some peace of mind. After all, it's one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So right now, if you're interested, you can get 50% off of your first month of confidential background reports. You just got to go to truthfinder.com/LC Sidebar. Now, during arraignment for both women, Deputy Prosecuting Attorney Erica Candelario detailed the allegations.
This case involves the starvation and murder of the defendant's 3-year-old daughter, as well as the starvation, beating, and restraint of at least 2 other children in the care of both defendants. Defendants, the state will note, are also facing enhanced sentencing given the torturous circumstances by which the minor victim died and the fact that she was under the age of 8.
Now, the defense, maintain their client's innocence.
There is the presumption of innocence. My clients are innocent until proven guilty.
The judge ultimately denied any kind of bail reduction, ruling that both defendants be held on a $1 million bail each. Marian, that seems to be the appropriate bail considering what we're talking about with these allegations. But my gosh, you know, it's just, again, unthinkable what's being asserted here. And now having videos, alleged videos of Sarai crying, where does that factor into the case?
Oh, I absolutely think it factors in. And of course, the prosecution will be able to use that video footage so long as they can establish authentication, so long as the videos survive what will likely be brought in terms of defense motions to suppress. They might claim that the videos were illegally or unconstitutionally obtained by law enforcement officers. So as long as those videos can survive not only a pretrial motion for suppression, but also any defense challenge to their authenticity, claiming perhaps some defense claim that they were doctored or created for purposes of this prosecution. But as long as they can survive those challenges, I would imagine that the prosecution will want to use those videos to show again, to prove again, not only knowledge, but intent on the part of the two defendants to inflict this serious injury and eventually end this girl's life.
And this girl died in June of last year. Why did it take so long for these two to be ultimately arrested and charged?
Right. Well, first of all, there's no, as you know, there's no statute of limitations on the homicide charge. So I'm not unduly offended by the length of time that it took for the investigation. I think that depending on the jurisdiction, the fact that all of the stakeholders in this investigation in terms of police, medical examiners, prosecutors wanted to get their full body of discovery together, meaning to complete the postmortem autopsy, to determine manner and cause of death, to look at any social services records, to look at medical records that may have existed, to gather these witness interviews and reports on what they saw and heard over a period of time in terms of the condition and the abuse of the children that was ongoing. I don't think that 7 months is an unduly long period of time. And I will state that with a qualifier that in the time, over the course of the investigation, I believe the other children, the 3 surviving siblings, had been placed in protective custody, had been placed in foster care. So I think that as long as the other children were removed from a potentially ongoing harmful situation, and that allowed the investigators to complete a thorough and comprehensive investigation, I think that that is a sufficient amount of time to make a charging decision on the part of the prosecutors.
And now it moves through the court system. And I'll tell you, the division administrator of the Department of Human Services Child and Welfare Services branch released the following statement, just expressing heartbreak over this loss. It said, "We are heartbroken over the tragic loss of this child and join the community in mourning. Every child deserves to be safe, and protecting the well-being of children is at the core of everything we do at Child Welfare Services. CWS works with its law enforcement partners and respects the need for confidentiality as the investigation in the case continues. Please know that CWS is fully committed to protecting children and taking appropriate action when concerns arise. Keeping children safe is a shared responsibility, and we encourage everyone to report any suspected abuse or neglect." Now, in terms of this pair, these defendants, they were due back in court yesterday for a preliminary hearing. And if the pair are convicted of second-degree murder, they're looking at the possibility of life without parole. Marian Braccia, thank you so much for coming on. Really appreciate you taking the time. I know this is a very tough case to talk about, but, appreciate you doing it.
Thank you, Jesse. Thanks for covering it.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.